The petitioner will be seated on the left side of the bench and the respondent on the right side, as I said earlier, which includes speakers and researchers. If the Honorable bench permits, may now invite the petitioner's counsel to commence their arguments.
Honorable bench, the counsel 1 is approaching. May I? We would like to address the bench collectively as your honor. May I? Ms. Chu. The counsel 1 is representing the client, the appellant. May I proceed to the facts of the case, your honor? I would like to direct your attention towards page number 8 of memorial submitted by the appellant. The facts of the case that the appellant is the absolute and lawful owner and possessor of immovable property and measuring 800 square yards situated in survey number 143, Banjara Hills, Hyderabad. The said property devolved upon the appellant by virtue of duly executed and registered last will and testament dated 15 September 2002, made by his late father, Sri Sitaram Kumar, hereinafter referred as the testator. The will stands uncontested and is valid in law. That upon the demise of the testator, the appellant entered into peaceful, continuous, open and uninterrupted possession of the aforesaid property and has remained in exclusive occupation thereof ever since. The appellant has been diligently discharging all statutory obligations by paying property tax, electricity charges and other municipal dues in respect of the said property. Pertinent documentary evidences substantiating the appellant's ownership and possession is annexed herein with of the pursuit of this honorable court. That in or around February 2024, the appellant discovered that the defendant's company, namely Nandan Developers Private Limited, had commenced unauthorized construction activities on a portion of the appellant's property and was erecting a commercial complex thereon. Upon verification, it came to light that approximately 200 square yards of the appellant's land had been illegally encroached upon and was being used for said construction. That upon making inquiries, the appellant was informed that the defendant purportedly acquired certain land from one Mr. Faizan Khan through a sale deed executed in 2023. However, the said sale deed pertains to an entirely different parcel of land and bear no nexus with the appellant's legally owned property. It is reiterated that appellant has neither conveyed, alienated, assigned, nor in any manner encumbered any portion of his land in favor of Mr. Faizan Khan or any other individual. I would like to direct your attention towards the next page, which is page number 9. That the appellant, upon being aware of the encroachment, immediately raised objections and called upon the defendant to cease all construction activities and to remove the unauthorized structure erected on appellant's land. Despite such oral and written protest, the defendant willfully ignored the appellant's objection and continued with illegal construction. That the appellant, upon approached the trial court seeking an order of temporary injunction, restraining the defendant from proceeding any further or interfering with the appellant's peaceful position. However, the said application was erroneously rejected on the grounds that the matter required adjudication at trial, despite the appellant having prima facie established ownership and said position. That the appellant is left with no other efficacious or alternative legal remedy, save and except to invoke the jurisdiction of this honorable court by way of the present suit for permanent injunction in order to safeguard his lawful possession and prevent further encroachment by the defendant. If the bench is satisfied with the facts, may I proceed towards the issues? What do you mean by encroachment? Encroachment is illegally trespassing the land, or in other words, having or taking the possession of the land illegally, where the owner of the land did not get legal possession through oral or written statements.
Is it defined under any act? If yes, where? Under which act?
Pardon? I beg your pardon.
Encroachment is defined under any of the acts? If yes, under which act?
I do not recall the act exactly, but it is defined under trespass. Trespass. And it can be defined under tort, and tort is not a codified act. There is no codified access.
What do you mean by injunction?
Injunction is a stay order or an order to stop something from happening.
Is it defined under any of the acts? Under which section? Under which act?
Specifically found.
Specifically, injunction.
Like orders of CPC, sorry, I beg your pardon. Under CPC, Order 39, Rule 1 and 2.
Are you aware of the types of injunctions?
I do.
How many types? Which are they?
The permanent injunction and perpetual injunction.
What is in the perpetual?
Perpetual is another name for permanent injunction.
Okay. Only the permanent perpetual injunction.
Now, there are two types of injunction as far as I know, wherein one requires an urgent injunction, which is temporary, which can be temporary, and later, after the court's order, it can be dismissed or accepted. And there is a permanent injunction, where it says that one has no right to continue any further, construction or whatever the party was doing on the land.
Proceed.
May I proceed with the issues?
Yes.
I would like to direct your attention towards page number 10. The council shall be dealing with the issues in five-fold way, where I, council 1, will be taking up issues 1, 2, 3, 5, and 7, and my co-council will be dealing with issues 4 and 6, followed by the arguments. May I?
Yes.
Firstly, Your Honor, I shall add the issue 1, which asserts that whether the appellant has established lawful ownership and exclusive possession over the immovable property measuring 800 square yards situated in survey number 143, Banjara Hills, Hyderabad, by virtue of a registered testamentary instrument dated 15 September 2002. Whether the defendant has unlawfully encroached upon a portion of the appellant's land to the extent of 200 square yards and commenced unauthorized construction thereon, in violation of the appellant's proprietary and possessory rights. Whether the appellant is entitled to a decree of permanent injunction under Section 38 of Specific Relief Act 1963, restraining the defendant from further interfering with the appellant's lawful possession and from continuing any illegal construction. Whether the erroneous denial of interim relief by the trial court has caused manifest prejudice to appellant's rights and adversely affected the preservation of the status quo pending final adjudication, whether the balance of convenience tilts in the favor of appellant, and whether the appellant would suffer irreparable harm and injury incapable of being compensated in the monetary forms. In the absence of injunctive relief, I would like to direct your attention towards page number 30. Your Honor, if the bench is satisfied with my issues, may I proceed with the arguments?
What is section 38?
Section 38 defines perpetual injunctions when it is supposed to be granted. May I?
Yes.
The appellant, Mr. Ramesh Kumar, is in undisputed, settled and continuous possession of the suit property measuring 800 square yards situated at survey number 143, Banjara Hills, Hyderabad. His possession is not transient or permissive, but rather derives from a valid subsisting title, namely and registered will dated 15 September 2002, executed by his late father Sitaram Kumar, which forms the foundational document of the ownership. I would like to direct your attention towards page number 119 of compendium submitted to the bench. I beg your pardon, page number 121 of the compendium. One two one, 121. A copy of registered will is submitted to the bench already. Where the testator stated that he is willingly transferring the property to Mr. Ramesh Kumar, the appellant. May I proceed?
Yes.
Under Section 38, Subclause 3 of Specific Relief Act 1963, a court is empowered to grant a perpetual injunction to prevent unlawful interference where the defendant invades or threatens to invade the appellant's lawful possession or enjoyment of immovable property. The appellant has adopted comprehensive documentary evidence in support of both title and possession, including blueprints of the scheduled property, which is again provided in compendium submitted to the bench. And I would like to direct your attention towards page number 190, 119 of compendium submitted. Then the conceptual blueprint layout, which shows the measurements. May I proceed?
Yes.
Receipts of the property tax, utility payment, registered bill, admissible under Section 68 of Indian Evidence Act 1872, subject to proof by attesting witness at trial. In order to substantiate my claim, I would like to refer to case of Krishnaram Mahale vs. Shobha Venkat Rao, 1989, where the Honorable Supreme Court held that the possession, even in the absence of ownership, is a substantiated right, and that no person may be disposed without following due process of law. And to further vindicate my claim, I would like to refer to K.K. Verma versus Union of India, the case law, wherein the Bombay High Court affirmed that possession is an interest worthy of legal protection and injunctive relief can be sought even without title where the defendant is a rank trespasser. The appellant has clearly demonstrated both legal title and continuous exclusive possession for over 2 decades. The defendant's interference is an unlawful encroachment upon a vested proprietary and possessory interest and must be restrained. I would like to direct your attention towards page number 14.
What is Section 68?
Section 68 of Indian Evidence Act states that when a document is required to be attested by at least one witness and was replaced by Section 17 BSC. Right, proceed?
Yes.
I would like to direct your attention towards page number 14. Next page. The defendant claims a right under sale deed executed in 2023 by Mr. Faizan Khan. However, it is categorically submitted that Mr. Faizan Khan never had any right, title, or interest in the appellant's land. Therefore, any sale deed executed by him, at least insofar as it pertains to the appellant's property, is legally void in eyes of law. As the legal maxim states, nemo dat quod non habet, where it states that no one can give what he does not. As Faizan Khan, the said third party, has no rights of the ownership which was allegedly passed by Ramesh Kumar, he cannot pass it over to someone else. To substantiate or vindicate my claims, I would like to refer to Meghamala versus G. Narasimha Reddy case 2010, wherein the apex court held that the person cannot convey better title than himself possesses. A transfer by a non-owner confers no legal right upon the transferee, even if the latter acts in good faith. Since Mr. Faizan Khan had no lawful authority or title, the defendant's purchase is void ab initio. The defendant's entry and ongoing construction over the appellant's land is therefore patently illegal and deserves immediate judicial restraint. Assuming argument that appellant's title was disputed, which is not conceded, that law still protects settled possession from unlawful interference, the defendant has not only failed to follow due process, but has acted in complete disregard of the established possession. To support my claim, I would like to refer to Krishnaram Mahale, wherein it stated that Even a trespasser in settled peaceful possession cannot be forcibly disposed. The appellant's 2-decade-long peaceful possession, coupled with evidence of tax payments, entitles him to injunctive protection. The defendant's self-help measures must be condemned and injuncted. I would like to add attention towards page number 15.
Whether the tax payment gives the ownership.
Pardon?
Whether the tax payment proves the ownership of the possessions.
Yes.
Where it is mentioned.
Because he is.
Evidence of tax payment.
Sorry, you didn't repeat the question. It is there in the compendium which we submitted. I would like to add attention towards page number. Leave of occupation bill is not this. Page number 122 of compendium, where a copy of utility bill is provided. And copy of utility bill states that he was in possession, he was enjoying the land, he was settled in there. May I continue?
Still not answered. Whether the tax payment gives the ownership of possession. What does it prove?
It proves that when the owner is paying taxes, he is the owner of that. That is the reason he is paying the
Where
tax.
it is mentioned, I am asking you.
In any section or any
Yes,
say
under
that.
which act, under provisions, under orders.
I apologize, but I don't know any exact act or section. Copy of taxes bills. It says that the taxes and bills show that he is occupied but does not possess.
Yeah, okay. So, do you aware of status quo?
Sorry?
Status quo?
The cause of action. Yeah, I see.
What do you mean by that? They are asking for a relief of injunction. They are asking for relief of injunction. What is the procedure there? What does it mean? You are praying for injunction.
Yeah.
What does it mean? What do you have to show to the judge or court?
Yeah. Yeah, asking for a status quo.
Yes. I'm asking for status quo. Explain.
Can you just elaborate the question? We are asking for like putting a stop to the construction that is being continued on the appellant's land. Yeah. Proceed. The balance of equities lies heavily in the appellant's favor. Should the defendant be permitted to complete construction, the appellant stands to suffer permanent deprivation of his land. The loss is irreparable as demolition of the completed structure may become economically and legally cumbersome. The appellant's proprietary right will be permanently compromised unless injunctive relief is granted. In contrast, the defendant has no legal right to the land and has proceeded with construction despite notice and protest, rendering its conduct willful and inequitable. Your Honor, now I would like to call upon my co-counsel who will deal with the rest of the issues called by the arguments. May I?
Yes.
Much obliged.
May I?
Yes.
Should I go with my local language?
Yes.
My issues are 4 and 6. Whether settled possession in the absence of formal package is sufficient to law to maintain an action for injunction against a trespasser for unlawful interference. My next issue is whether the defendant has acted with malified intent and in willful disregard of the appellant continues an open position, thereby vacating any claim of bona fide under the allied sale transaction. May I go for the page number 3? Yes. Denial of interim relief does not bar permanent injection. The refusal of interim injection by the trial court was solely on the procedural ground that further trial is necessary to establish title. However, such an interlocutory decision does not foreclose the grant of permanent relief upon conclusion of evidence. Case 1, as in Dalpat Kumar versus Farhad Singh 1992 SCC 790. In that, the apex court held the interim injection are based on prima facie view and do not bind the court at the final stage. Permanent injection may be still be granted based on full trial findings. The appellant has now brought forward a complete set of documents and is prepared to establish his case through examination and of witnesses. The court is empowered to grant the permanent injection, notwithstanding the earlier denial of interim relief. Page number 16, issue 6, argument 6. Settled position sufficient for injection. May I, sir? Yes. Legal recognition of settled position. It is a well-established principle of law that settled position, even the absence of ownership or legal title, is sufficient to seek an injection against a trespasser or unlawful dispossessor. The law protects position to prevent anarchy and self-help and ensure disputes are resolved through due process. Protection of position, even without title. The person in peaceful, open and continuous position cannot be disposed without following due legal procedure, even by the rightful owner. The rightful remedy is a suit for position under Section 6 of the Specific Relief Act 1963, not self-help. As per Section 6, the Specific Relief Act 1963, if any person is disposed of immovable property without his consent, otherwise than in due course of law, he may file a suit for recovery of position, notwithstanding any title. The section clearly affirms that even a person without ownership has the right to protect position against unlawful dispositions. As the held in Ramegowda versus M. Vadadappa Naidu 2004 SCC 769, Supreme Court clarified that settled position means position over a sufficient long period that is open and without concealment, and such a person is entitled to legal protection. Yes. Because only
You go ahead with your explanation on your reply.
Sir, appellant professional, more than 20 years position. Sorry. Sorry, sir.
what I am thinking, whatever you are expressing, comments, that you have to express in your own words, you can express. That it will be further whenever you find just to express in front of lordship. But then you can be very good in position. So now you are being in the position of learning. You do not know you can what you know and how you can express with the what you know. And I don't know this what I need you have to do. Yes.
I would like to call my teammates to add the bench and conclude the argument with a prayer. May I?
And we humbly submit to the honorable bench that in the view of following facts and legal submission, the appellant most respectfully pray that this honorable bench may be pleased to pass the degree of permanent injunction, thereby restraining the defendant, its agent, servant, and employee, representative, contractor, assigning, or any other person claiming through or under it any manner trespassing, interfering with or disturbing the appellant peaceful position, use, and enjoyment of the immovable property of it at measure 800 square yard situated in survey number 143, Banjara Hills, Hyderabad. Continuing undertaking any construction activity over the enclosed portion at measure 200 square yards, which form an integral part of the appellant property. Furthermore, declare that the defendant has no right, title, interest, or claim over the aforesaid portion of the appellant land, and that the legit seal relied upon by the defendant is not binding upon the appellant. Direct defendant to forthwith remove any unauthorized construction or structure raised on the enclosed portion of the appellant land at its own cost and to restore the site portion to its original condition. We most respectfully pray to the honorable bench to avoid cost of the suit and indicate proceeding in favor of the appellant and against the defendant, and grant such other further or consequential relief as this honorable court may deem just, fit, and proper in the fact and circumstances of the case and in the interest of equity and justice.
When the illegal construction has begun on your property,
Yes, ma'am, sorry.
when the illegal construction has
February
begun on your property,
2024.
huh?
February 2024.
February 2024,
Yes.
and when you filed a suit for the eviction,
At first, we gave them the oral, a warning type something. Then we went
oral warrant,
like we asked them to stop the trespass.
when I said when you filed a suit,
When did it? After the trespass, after the construction.
on which day, on which date? February 2004, 2024, the construction has begun. And when you filed a suit, it was already constructed over
February
there.
2024. After that, February 25.
Within 3 months.
1 year. What year was leaking for 3 months?
Sorry?
What is that? 2024 and 2025 you filed.
8 2025.
8 2025. And when the
8
construction,
February. 25 February 2024.
25th February 2024.
Yes.
And when you filed a suit after 3 months,
Yes.
what you was waiting for?
At first, when we asked them, when we approached them, I said, we orally asked them to stop the process and construction. They at first agreed and then they illegally constructed. After agreeing also they started construction and continued the construction. And upon when we approached to the court, at first they were not they did not give us injunction urgently and they asked it for the trial.
Have you asked for the relief of injunction?
Sorry?
To whom you asked for the injunction?
To the lower court.
To the lower court.
Yeah, and we rejected saying that it requires a trial, but we needed an urgent injunction, so we had no option left to approve the senior.
So you lower court verified
After 3 months.
after 3 months. 3 months you waited, you requested them orally.
Yeah, and we even approached the local police station, wherein
And you have a copy of that?
no, that was not.
And that is done orally with the police station.
Yeah, because they said that within the settlement, if it is possible.
Thank you for your arguments. We will now pause for a 5-minute break to allow our respected judges to evaluate the performance. Spectators are kindly requested to remain seated and maintain decorum during the break. We will resume shortly with the respondent round.